Welcome to the Hastings Shadmehry Show with your hosts, Hastings and Mali Shadmehry. Dive into the heart of family law as Andee and Mali bring clarity to legal challenges, celebrate client victories, and share the wisdom of their combined expertise. Get ready for a journey into empowerment and advocacy right here where your story matters.
Welcome to the Hastings Shadmehry Show, where we delve into the heart of family law and the stories that shape our lives. I'm Mali Shadmehry, and joining me is the ever-insightful Andrea Dyer Hastings. How are you today, Andee?
I'm doing great, Mali. How are you doing today?
I'm doing well, ready to get going on the fun topic we have planned for y'all today. But I have to ask before we go. Andee, today, are you feeling like a warrior or a diplomat?
A warrior.
Why is that?
100%. Well, we've just got a couple of cases right now that are getting ready to go to trial, and we have opposing parties and opposing lawyers who are taking what I view as ineffective stances. And so that definitely brings out the protector in me for our clients.
Love to hear it.
How about you, warrior diplomat?
Warrior. And I know, big surprise. Big surprise. Here's why. I was listening to a podcast the other day, and it was talking about how in the holiday season, everybody likes to get a little lazier, take it easy. And that's the time for the warriors to come out. This is where we shine. We keep working. We keep persevering. We stay consistent, whether that's in business, in the gym, whatever it is. With your diet, stay consistent. That's what separates the winners from the losers. And for me, the holidays and fun times coming up, that's great. That's something to look forward to. And we want to maximize our time with our families and fully be invested in those moments. But the best way to do that is also to continue to maintain your accountability, keep the routine, keep prepping for those trials just as hard as you would on other days. And I'm telling you, you'll beat your opponent. You will beat your opponents by doing that if you're, in the courtroom setting. And also it's just staying accountable and entering into the new year on top of your shit. To be honest. Can I cuss on this? Yeah. Because this is our show. We're adults. So that's where I'm at. Ready to knock out everything as we get through the holiday season and hit 2024 hard and with everything lined up how it should be. So with that, we're going to just segue into what we're talking about today. Today, we are talking about custody. Kids, kiddos. One of our favorite things to talk about. We're just going to talk about the different types of custody and what they look like and some problem areas and those sorts of things. So, you've got two different types of custody: legal custody, physical custody. Those are two different things. Let's start with legal custody. What is that? What are the different things we consider when we look at that, Andee?
So legal custody is decision-making, essentially. Access to information and the ability to make major decisions impacting the lives of your children. So in family law cases, we start by breaking down decision-making into four common categories. That's educational decision-making, medical, extracurricular activities, and religion, although that's not as commonly designated anymore for reasons that we'll get into. And what type of legal custody you have and how that looks is going to depend on a lot of factors in the case and the involvement of the parties and that sort of thing.
Yes. So again, two different types of custody. A lot of my clients come to me very nervous about that. Explain custody. And that's a normal, valid question. So again, legal custody is decision-making for those four different areas for your kids. And physical custody is physically who has the kid. And we'll get to that part in a second. Under the realm of legal custody, there's different ways we can do it. You can do joint legal custody. What is joint legal custody?
That's shared decision-making and shared access to information. However, even when you have joint legal custody, which is the most common designation these days, generally courts want both parents to have access to information, records.
Okay, that's what I want to ask. What kind of information are we talking about? Equal access under joint legal custody, what does that mean?
Well, for instance, access to your child's medical records, because it's not uncommon that one parent takes their child to certain events or doctor's appointments and that sort of thing, but both parties should be able to participate and have access to that information. So it's their school records, their medical providers, all those sorts of things. When you have joint legal custody, you automatically have access to all of that. You don't have to rely on your spouse, soon-to-be ex-spouse, as a gatekeeper for that information with your children, which is really important in a lot of our cases.
So we're talking about these 4 different areas: religion, extracurricular, education, and medical. So what do we do? What typically happens in, who gets to have final say? What does that look like?
I feel like I say this a lot. It depends.
Yes.
Which feels like a very lawyerly response. However, it really does depend. It used to be that whoever was the primary physical custodian typically was the final decision maker. And that doesn't change the fact that both parents have access to information. But in these major categories of decisions, education, medical, extracurricular, all those, somebody has to be the final decision maker in the event of a disagreement. We call it the tie-breaking decision maker. It can be one parent who has final decision making on all categories. I think we're seeing a lot more now where the parties are dividing up the categories. So perhaps one parent has educational decision making while another parent has medical. And I don't know if you've seen this, Mali, but where that can get a little funny is, let's say a child is diagnosed with ADHD and affects their education. So what is that decision making? Is it medical or educational? One of the things that we deal with. So it's not as simple as it looks.
Yes. So here's what I will add. The court is going to look at the history of what's happened before this divorce was filed. So what I happen to see a lot of the time is that one party has traditionally handled the majority of educational stuff for the kids, whether that's a child with special needs. We have a lot of that. And they need special attention. They need special programs at the school, special teachers, whatever it is, maybe some mentoring or tutoring, special things. We are typically going to have seen that traditionally, before divorce was being contemplated between these parties, one of the parents was handling it more than the others. Sometimes we see that they did equally share that responsibility, but that's more rare in my experience. Same thing for medical. When you've got a child that's got serious medical issues, usually one person's been handling it more than the other, even if they don't have serious medical issues. Okay, especially with our young babies, our infants, and like anywhere from 0 to 4. We see one parent more than the other that's been taking them to more appointments and things like that, talking to the medical providers, administering the medications, and watching how the child's progressing. Of course, with really young children, we see a lot. We've got like constipation issues and eating and their eating habits, and they need to go to a specialist to help them with their eating habits and all those sorts of things. We've got parents that are highly involved in that. And then, of course, same thing with extracurricular and religion. Education and medical tend to be the most hotly disputed, topics, especially with younger babies. But with our older kids, with those kiddos, extracurriculars become a big deal as well, especially when we've got kids that are really talented and doing all different types of sports. And again, yes, we usually see that one parent handled those duties with the child and their development in that area more than the other. The cases where parties have equally shared those duties tend to be a little smoother in how we work that out. And it's just more rare when you're in a hotly contested divorce action, but that's okay. Don't let it intimidate you. We deal with it all the time. And there are ways to find solutions that are creative for every family. And that's what's most important, is that you get a family law attorney that, again, specializes only in family law. Again, you've heard me say it before. The dabblers, the people that don't do these special parenting plans, all day, every day, like we do. That's the parenting plans that I see. Somebody threw something together that they thought it was pretty good. They worked out decision making, but they didn't carefully cater it enough. They didn't curate it to this family's specific special needs. And it creates a situation where people have to come back to find an actual family law attorney years later to say, this parenting plan isn't working. So-and-so is violating it because it's drafted badly and it just doesn't even fit the kid's needs. Circumstances have changed from the date we signed off on this plan. We need help. We need to fix this. And you're signing yourself up basically for double litigation. You're signing yourself up for a parenting plan that doesn't live and breathe and grow with your children as they age. And you're going to have to come back to an expert in the future to fix it. But I would say good 40 to 50% of my clients on a yearly basis, they are people that have come to me after already having been divorced years previously, but the parenting plan is not working and we've got problems. They come to me and I say, we got to redo this whole thing. And it wasn't drafted properly. It's not properly curated to your children's needs. A parenting plan is a document that we draft that y'all either agree on or judge orders at trial. And it outlines what we're talking about, what we're doing with legal custody and who has final say. And it's not just a template, and too many lawyers treat it like a template. It is a document that needs to, again, live and breathe with your family as your kids age up to age 18 years old. That's when a parenting plan stops taking effect, when they reach age 18. So it's not a little deal. Everything, even things as simple as a comma being in the right spot, those things are important so that we're not dealing with loopholes and people arguing over, unnecessarily arguing over things. And so on this topic of how do we determine who has final decision-making authority, like I said, what we typically are going to base it on is historically who is handling that stuff. And we do things like we can go pull the medical records, the school records, all the school emails between teachers and whatever to show that paper trail of who handled what. Because oftentimes what we see is that there is a party that wants to be ugly. And again, we all assume there's going to be an ugly party in a divorce. Yep, we see it all the time. And what we see is that somebody's going to threaten by using the children as weapons. They're going to try to threaten the other party to settle in their favor. And they're going to say, no, I'm fighting for final say on medical and I'm going to get it. And they will try to fight it till they're just blue in the face. But what I always remind my clients of is, look, the fact that they're trying to take that stance now, and also what we see a lot is that they suddenly, while the divorce is pending, now they're going to take them to the doctor's appointments. Now they're suddenly emailing the teacher every day. Oh, what's so-and-so doing at school today? I am an involved parent. Please tell me. Okay. Well, they're putting on a show because we're in the middle of litigation. And I always remind my clients, and it works my clients up, and that is okay. That's valid. It's scary. When someone's coming after your babies and trying to create a narrative that was not reality when the marriage was, intact, that's a scary and frustrating situation to be in. We see it a lot. So I'm going to validate you. It's okay to be upset about that. But a good lawyer is going to remind you, look, it doesn't negate the fact that there's a history there. The judge would pay attention to that. Just because you want to behave to look good in the divorce does not mean that history is erased. We've got documents. We've got a paper trail. We know we can call teachers to testify if we wanted to. Sorry, teachers. We try to leave you out of it, promise. But we could, to show who's really been more involved. So that's one of the common fears that I see is why are they suddenly behaving during the case and trying to participate when for 4 or 5 years they were not participating at all. They can't tell you what the medication protocol is for this child and what this child likes to eat before bedtime and all this, but I can because I'm the one that's done it. Why suddenly are they doing it? It's a fine line. Courts want to see both parents be involved, but they're not going to ignore who's traditionally handled those roles. So it varies by case, as Andee said. Typically, judges do like to say, look, I'm going to give both parties some final say. Somebody's going to get final say education, some medical, somebody gets extracurricular, and somebody gets religion. As Andee said, religion, a lot of times what we say is both parties are able to take the child to their place of religious, preference on their own parenting time and those sorts of things. But again, just varies by family. And what are the important things to both parents about how they raise their children? Some families, religion's more important than others. Some families, education more important. So
some families, one of the reasons they don't agree is because they don't agree on religious basis. So that's sometimes an issue that we see play out in these cases. One thing that has hit me recently, and I don't know if this has been your experience, Mali, but it is not unusual for, and I think you touched on this, for one party to try to use the children as a weapon in the divorce case. It's not uncommon for one party to be very kid-focused, and that's kind of their Achilles heel, so to speak. Yes. That's the thing that matters to them most. That's the thing they want you to fight for before all else. And so sometimes we see that as one party will try to weaponize it to get at that person. Sometimes they'll weaponize it. It's not unusual to see situations where certain parties take positions on custody because they want to increase the child support they may receive or reduce the child support that they may pay. And so those are all factors that come into play. It is absolutely what Mali said. It's a living, breathing document that we have to put together. And our jobs as lawyers is to look at the problems you're dealing with now. How do you all interact? How do things happen for your children now? Address everything that we can see and everything we can anticipate based on our experience doing family law exclusively, and try to reduce future litigation as much as possible, which is exactly what you were talking about. And part of what we use to anticipate that is the behavior of the parties during the case. We can't account for every possibility, and that's frustrating for clients sometimes. I think that you know something's going to happen, but there's not a way under the law to address it specifically. And that can be very frustrating because I find that clients, they really want, they don't understand. I know they're going to do this. I know this is going to happen. Why can't we put this in the document? The flip side of what we're talking about is sometimes judges, because their emotions aren't in it. Our emotions are in it for our clients, but we still maintain the objectivity to make the arguments. But judges sometimes want to give a parent an opportunity to parent and to step up to the plate, so to speak. And so that's kind of the flip side of, the arguments on who has traditionally done things. Sometimes people feel very threatened in a divorce that they're going to lose their kids because they hadn't been involved before. And now they're going to be in separate households. So, we deal with every aspect of it. There's so much in figuring out custody, because my experience has been there's nothing more important to our clients than custody and the safety and well-being of their children. And so I would say, I'm curious as to whether or not this is your thought, Mali, that is probably the area where we do battle the most. I hate to speak in absolutes, but I would say the most of where we do battle is in custody. Do you agree?
Yeah, for sure. And yeah, we'll definitely fight it to the death. And, there's nothing more important than making sure our future generations of children are brought up in households that are as healthy as possible. And that's one of the reasons I love family law, is that, the dissolution of a family unit, that's just our reality. That's part of our culture here now. And we have the laws, they exist for a reason, because this is an issue. We get divorced in America, that's okay. And therefore, it takes having responsible attorneys that can help craft reasonable and responsible solutions for these parenting plans and things, so that these kids can be raised in hopefully healthier environments. Now that the marriage is dissolved and we can have happier parents, we can bring up future generations in a healthier environment. So that's a big part of our purpose, and it is why it should be a very important part of every case. Let's make sure our babies are getting protected when we're dissolving a marriage, and let's make sure our future generations are being raised in households, that will allow them to optimize their talents and thrive. So, okay, a few more things here. We talked about joint legal custody. I wanted to note that there is something called sole legal custody as well. It's very rare, more rare. And really, that's a situation where one party should not or cannot have access to the children's documents and those sorts of things. You're not going to get any final say. There's going to be no consulting between the parties. We didn't talk about good faith conferral, but part of having joint legal custody, which is what the vast majority of people have, part of that joint legal custody, yes, somebody's going to have final decision-making authority on those 4 areas, but they're going to be required usually to confer with the other party before they make said final decision. Y'all are going to be forced in your parenting plan to communicate, look, I want to sign so-and-so up for soccer. What do you think about that? And the other party gets a chance to weigh in, and then you got to make your final decision. But if you have sole legal custody, usually that's somebody that's been incarcerated. They're in prison. They've done something wild. I had somebody shoot up somebody with an AK-47, and he went to prison. That was a sole legal custody case. He's not going to be consulted about if so-and-so should go to soccer or whatever. So that's a little more rare and is so fact-specific that your lawyer needs to chat with you about that when you consult. But let's quickly hit on physical custody. Remember, we started and said there's two types of custody, legal and physical. We've hit legal, but physical custody, there's also different parameters there. You can have, usually you're going to see somebody's going to have primary physical custody. You can also have joint physical custody. That means sharing your children 50% of the time, and sole legal custody. So 3 kind of divisions there. And again, the sole legal custody sole physical custody is kind of similar to what we're talking about with sole legal. Very rare. We do have sometimes people saying, I want sole. They don't ever need to see the kids again. And it's very rare, very fact specific. And you're usually looking at somebody's in prison or something like that. So Andee, will you educate us on what is the difference between primary and joint legal custody and kind of what factors the court would consider in determining how we do that?
Absolutely. It sounds obvious. Usually when it's joint, the time split between the parents is about 50-50 or close thereto. With one party designated as primary, it doesn't mean that the other parent does not have rights, so to speak. It's just acknowledging that there's one parent who's going to have the children more of the time and do a little bit more of the day-to-day heavy lifting with the children. But, gone are the days where the standard parenting time arrangement is an every other weekend and a dinner in the off week. That used to be kind of what was considered standard when you have primary physical and secondary physical. And now, we see a lot more because it's important, especially given the ages of children, if they're younger, that they have more frequent contact with each parent. So we'll craft parenting plans that take that into account. If there's one parent who's traditionally handled academics, then, we may want to make sure that the kids are with that parent on Thursday nights because Friday mornings is usually when they're taking tests. I mean, there's so many details that we look at and take into account when coming up with a parenting plan. So, again, somebody can have primary, but the other parent could have, and I see this a lot, and I'm sure you do too, like Thursday after school until Monday return to school. That's obviously a much longer weekend than what we used to see. Mm-hmm. And the court is going to look at, obviously the court's responsible for investigating what's in the best interests of the children and what makes the most sense for them. Some of the things they're going to look at is who's providing the care, what is the care that's required, how far apart do the parties live. Trust and believe that if people, especially in Metro Atlanta, if you live 40 miles apart, it's much less likely you're going to have a joint physical custody arrangement. Mm-hmm. But those sorts of things, because kids can't sit in cars for hours at a time, especially to and from school. So these are factors that the court's going to consider, and there's so many. I mean, I could talk probably all day. I would say if you're facing a divorce and you anticipate there's going to be custody issues, start creating a timeline. Create a notebook, a journal that you keep track of. What is it your day look like with your kids versus your spouse's? We can use that information later, like Mali said, mm-hmm. to show the history and pattern of what's gone on. Mm-hmm. And you won't remember it if you don't write it down. Trust.
Yeah, especially when you're in an emotional, scared kind of state of mind going through a divorce.
Right. That's right.
I have had happen multiple times where somebody, usually mom, has been primary caregiver of the child. Truly, if you look at calendars and you go back and who did the primary caregiver duties for the majority of this kid's life, it's one parent versus the other. But then when the litigation is pending, the other parent says, I was primary caregiver. I see that all the time. And then you got to go disprove that. So that's what I think you're getting at too. If you can collect some data, and a calendar's great, what have you, to show this is kind of what life looked like for my family. Because again, it's like I said for the legal custody part. In physical custody, the court is going to look at the history as well. Just because somebody suddenly says they were primary and they want to participate more does not mean it erases what y'all actually did. So the court will consider that. And then one more thing I was going to add. On joint legal custody, the 50-50 custody arrangements. It's a common misconception that if you do joint 50-50 custody, there's going to be no child support. There could still be child support. But we see a lot of people that want to weaponize children and benefit financially from the custodial arrangement by saying, I want 50-50 custody because they don't want to pay child support. So that's just one thing to note. Additionally, our courts are, becoming more and more open to doing 50-50 custody. And I think what I've learned over the years is that from experts and judges and all kinds of professionals in this area, children benefit to as much access as possible to both parents if both parents are good candidates under the best interest of the child statute 1993 in Georgia. And, kids having exposure to both parents as much as possible is seen as really good for their psyche. So if there's a way to do it, judges are going to probably strongly consider it. Some of them are really opposed to it, but that's starting to change more and more. So it's becoming more and more frequent that we split 50-50 custody. I mean, it used to be a thing also that when we determine holidays, because when you're determining custody, physical custody, we also handle your holidays. That goes in your parenting plan. Your lawyer would work that out with you, what holidays should look like. Generally, we split them pretty equally throughout the year. But in summer, for summer break for kids, we used to, in Georgia, just typically do the non-primary physical custodian would get 2 weeks in the summer with the kid. Now we're starting to see that we split the summer in half. Even if somebody has primary physical custody, we're typically splitting summer in half if the other parent's a good candidate under 1993, best interest of the child, when we weigh all these factors. So I would say this. You're potentially a good candidate, your family is a good candidate for 50-50 custody if you're going to be living in close proximity to one another after the divorce. And if you're able to co-parent, if you're able to have conversations that are respectful and actually have conversations that are based on what's benefiting our children, not what's benefiting me and what's benefiting me in this divorce and financially and whatever else. If you can't meet those two basic criteria of geographical proximity as well as the ability to co-parent, you're not a candidate for 50-50 custody. So that's something to seriously think about. And that's kind of all I've got talking about physical custody. I know we're going to hit on that again as we talk about more things later in other episodes. Anything else from you, Andee?
Not today.
All right. Well, thank you guys for joining us, and we will see you next time.